Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In human rights topic, I tell you that the persons set in under trial prisoners, they languished in jail for more than the punishment period. So it is definitely violation of human right. Right to liberty is violated. So to tell this, I have given the example of Rudal Sah case. It is a landmark judgment on the judicial activism as well as the proactive approach of the judiciary. You can read the case as Rudal Sah, S-A-H, Rudal Sah versus State of Bihar, 1983, AIR 1086. You can refer to the page and get the judgment also. Actually, it's a root cause or it's a distinction in the matters of state liability for violation of Article 21 of the Constitution of India, or it paved the way for the compensation for violating the human rights under vicarious liability. So, three judges bench. Justice Y.V. Chandrachud, who is the father of Project D.Y. Chandrachud, and Rangnath Mishra and Amarchana Sen, while deciding the case, they awarded compensation of 30,000 to the so-called prisoner Rudal Sah. What happened? So this Rudal Sah, Rudal Sah, he was arrested in the year 1953 for murdering his own wife. Right? The case went against him, and after due trial, the local session judge awarded life sentence to him. But he went in appeal. While serving the sentence, he preferred the appeal. So in the appeal, the appeal was allowed and the case against him was acquitted by the session judge Muzaffarpur on 3/6/1968. He was arrested in the year 1953. Right? So the appeal was successful in the year 1968. Almost he has suffered for 15 days or so, 15 years. But please remember, the date of release is 16/10/1982, after 14 years. So as section 31 CRP says, life convict should be there for 14 years. But already 15 plus 14 years he was there. Right? So actually his plight was highlighted in the media, and a public interest litigation was filed in 1982. Right? The plaintiff or the petitioner, Rudal Sah, he demanded redressal from the court for his illegal or unjust detention, not illegal, unjust detention. So why this thing happened? If you go to the affidavit of the other party, counter party, that is jails department, the stunning facts will be revealed, but of course court did not believe the same. The jailer filed affidavit stating that an order was issued by the acquittal judge, that is ADJ, to keep this person or Rudal Sah behind bars until further notice by the state of Bihar and also Inspector General of Prisons. Point number 2. Why? This will be explained. He was declared incapable of facing the trial because of his mental unsoundness. He was not mentally sound. He was showing the insane behavior. So since he was suffering from the so-called insanity and the medical report is there, he was detained in the jail. But when the court asked for the medical report clearly stated that he is not insane. He is sane. There are no symptoms of insanity against him. That means he was purposefully detained in the jail, taking advantage of the order of the ADJ. Right? Now, the contention of the petition is that he was kept in the prison in spite of the acquittal for a period of 14 years, not 1 day or 2 days. So, the Supreme Court clearly stated that it's a flagrant or direct violation of the human rights under Article 21 of the Constitution of India, which deals with the right to life and right to liberty. This is a point of liberty. He should have been set at liberty after the verdict of acquittal. even though he is insane, he is a mentally challenged person. What harm? The relatives would have taken him to a private hospital, is it not? So it is a flagrant violation of the Article 21 as per the opinion of the Supreme Court. So therefore, please remember, the state has to compensate him 30,000 and as a temporary measure and 5,000 toward the cost of the litigation. And please remember, the state should pay some money for the anticipated medical care also. The government itself, the jails department itself says that he is not sane. Therefore, to get the treatment, the state has to spend the money. And while awarding compensation, the court noted that compensation is a curative measure for the wrongdoing of the instrumentalities or the departments operating in public good. Department, jails department, police department, definitely they are doing for the public good, but they should not detain persons like this. So normally, previously, I think 964 judgment, Kasturi Lal versus State of UP, that judgment has protected the public servants. Normally saying that the public servants cannot be taken to task and there is no so-called vicarious liability like that. But this judgment has overruled the Kasturi Lal judgment also. So as a temporary measure, 30,000 was awarded. So and he was given leverage also. The petitioner was given a leverage that he can file a lawsuit for the lawsuit against the concerned state, that is UP, against the state as well as against the officers, that is jail officers, or against the erring officers to obtain the proper damages. He can go to the civil court also. So there is a very good judgment on the judicial activism on one side and the so-called compensation on the other side, and the wrong for keeping persons inside the jail without trial or more than the period. Thereafter only the amendment to CRPC came, stating that if at all any person is detained for more than half of the sentence period, that is, suppose if you take a murder case, a person is arrested in the murder case, the maximum punishment for murder case is 3 years. If he is there in jail for more than half, that is 1.5 years, he has to be released on bail. That's all. So this judgment paved the way for a radical action by the Honorable Supreme Court of India. Good judgment, read it and enhance your legal knowledge. Thank you.